what has actually transpired. So I'm very, very pleased that we have with us today our three panelists from the media who were heavily involved over the last couple of years as to what actually happened within the Afghan data breach. We have with us Holly Bancroft. A very warm welcome to you, Holly. Holly is the Home Affairs correspondent for The Independent. We also have with us Larissa Brown, who is the defence editor at The Times. And I'm also very pleased to welcome Sam Greenhill, who is the chief reporter at the Daily Mail. Now, in order to set the context, and also, by the way, before we delve further, just a note for members that they should not be asking or compelling the witnesses to reveal any information that has been provided to them in confidence. That would potentially be an interference in court proceedings as well as a breach of confidence. Now, we were advised in the House on the 15th of July, the Defence Secretary made a statement to the House revealing that a significant breach of personal data of thousands of Arab applicants and their families had been made. The incident itself actually took place in February 2022, but was not discovered until August 2023, when we were alerted, or when the government first became aware, and it was alerted by an individual, a private citizen referred to as Person A. I'd also like to commend journalists for their grit, their determination, and their pursuit of the truth and to expose exactly what happened. And I know that also, while he's not here with us today, David Williams of the Daily Mail was the first journalist to approach the government about the incident on the 17th of August back then, and I'm glad that he will be providing evidence to us at a later date. Subsequently, different journalists became aware of the data breach at different times, including Lewis Goodall of the newsagents. I know that all three of your good selves, as well as Lewis Goodall, were invited by the judge to address him directly during the course of proceedings. So that's the wider context, but we all know that this has had a massive impact on so many people's lives, those who had served not just our country, but those Afghans who had bravely supported our troops and our government. And that's why we owe it to them and their families to shed light on this. So let me kick off, if I may, and Larissa, we'll start with yourself, Ms. Brown. Now, you all wrote in July, when the super injunction itself was lifted, about the experience of being involved in court proceedings. Do you have any reflections now on, in the light of the passage of time, have you changed your opinions in any way? And if you can just speak regarding what you submitted and what your reflections are now, please.
Yeah, of course. I mean, it was obviously a really frustrating period for all of us. And this went on for, in some cases, 18 months, if not 2 years for some of us. And I think looking back, one of the sort of key moments was we were heading into the general election, and there was a small number of people that actually knew about what had happened, and I personally felt it could become an election issue. And I raised that with the judge in court in 2024, in I think it was January, February time. And what we knew was that the government of the day had put at risk potentially 100,000 people. In fact, the MOD's case, they were saying that these people could be at risk of death or torture. And we knew that they were making huge policy decisions behind the scenes, and obviously the public didn't know about that. This was at a time when there was a lot of discussion about immigration, yet they decided to secretly bring Afghans here who had been affected. And that was really concerning for us, because we believe that the public should know about that.
Yeah, that was under the ARR scheme.
There was, under the ARR scheme, the Afghan response route. That was a scheme set up to bring the Afghans here who had been affected by the data leak specifically, but Afghans did come in under different schemes as well. So that was sort of the first thing, is that we felt that the public should know. I was also, for me it was quite hard because I had been campaigning for the Afghans for years to get more of them to the UK, those people whose lives have been affected by the Afghan war and their service with British troops. And I was in contact with a lot of them. In fact, I just published my book, The Gardener of Lashkar, which was about the Afghans and their plight. And yeah, I'd be speaking to these people, and I knew that their names potentially were on a list of thousands of people, and at any point the Taliban could get hold of their names and come knocking at their door. And that was really difficult for me, and I knew that I couldn't tell them about it, and they didn't know. They didn't know for the whole of this time that their names were on this list. That was something else that concerned me. And then also, as defence editor for the Times, I was writing about what is the MOD going to do with all this new money for defence? And yet I knew that they were planning to spend billions of pounds on handling this fallout. So when I was writing, they could spend money on this, I was actually thinking, well, actually, billions of pounds of this might be going on the data leak itself. Yeah. So those were the things that I found particularly challenging. And I also tried throughout this process to try and hold the government to account for what was happening and try and find a way of writing about it without breaching the terms of the super injunction. And the only way I was able to do that is to write about General Sir Gwyn Jenkins at one point, because he had been asked by a minister if he was going to resign over the issue, and I was able to write that the issue he was asked if he would resign over was a national security incident. And that was all I could write at that point. But I think we all were just desperate to get something into the public domain so people could know what was going on in some way, but obviously we were really restricted.
Thank you very much. Mr. Greenhill, further to your reflections that you set out in July, with the passage of time, any other things that you would like to place on record, please?
Well, certainly I'd echo everything that Larissa said. But since July, on the 15th of July, John Healey proclaimed himself deeply uncomfortable at the lack of transparency. And I think he said to all the MPs that after 2 years of secrecy, all that would change. And I think we've all found that in the period since then, it's been something of an uphill struggle to get answers to basic questions out of the MOD. Several of the emails questioning things that I've sent to the MOD have simply been ignored. And on one occasion, I eventually resorted to an FOI just to simply find out a date, which took 4 months eventually to get, but I still haven't heard it from the MOD press office itself. So in terms of has anything, you wonder if anything has changed since 2023 when the MOD so alarmingly easily slipped into a most unprecedented...
It's very disconcerting to hear that you still feel that there's a lack of transparency from the Ministry of Defence to the questions that you are posing.
Yes, well, some questions have simply been ignored with no explanation.
Okay. Well, no doubt we will come on to these issues. By the way, during the course of our session, whether it's in terms of the impact of the secrecy, whether it's in terms of resettlements, whether it's accountability, so we will be delving into this. Members have got different areas that they do want to focus in on, including risk assessments. But Ms. Bancroft, what are your views further to your submission in July, and what else would you like to place on record at the outset, please?
I think kind of post the super injunction being known about, it just came to me, it kind of has been imparted to me that the whole process was something we couldn't go away and ask external experts for their views. We couldn't get answers to questions because we were under a super injunction. The MOD also didn't want to investigate anything that was presented to them. There's many examples of caseworkers bringing examples to them that weren't investigated. They also didn't, until the RIM review, go to any external experts. So the actual court process itself was a lot of hypothetical exercises as to what might be the case if XYZ happened, but not being able to rely on much actual external expertise. And I think kind of having it being lifted and also the exercise of the RIM review, does shed light on some of the issues. And I think it just shows me what a kind of very closed process it was, that it's not actually possible to during that process to kind of have basic answers to basic questions, and also the MOD wasn't investigating to find out basic answers to basic questions. And then also, one thing I am personally concerned about since the lifting of the super injunction is the movement of people out of Afghanistan and out of Pakistan. Seems to me to be very not happening very much. And I don't know the answer for why that is, but I think you guys should try and find out as to what has slowed down the process of evacuation. Why is it kind of become very difficult to get people out?
Ms. Bancroft, your views are duly noted, and let me reassure you that the committee has every intention to conduct a comprehensive inquiry, and during the course of the coming months we will be taking evidence from many of those who were involved and trying to get to those to the bottom of things. But my colleague Lincoln Jopp wanted to come in on this particular point.
I did. Thank you, Chair. I want to go all the way back to the breach itself, if I may. In your investigations, your dealings, was there? Can you give us a sense of the extent to which it was just an assumption that it was a cock-up, or that did anyone entertain the notion that it had been deliberate?
Well, this is actually really important because we were never told how the leak had happened. So we were going into an election period where it could have been a minister for all we knew. We had no idea how it transpired. So sort of we did investigations over that time, didn't we?
We did, but I mean, right at the very beginning, in August 2023, when you mentioned my colleague David Williams found out about it and asked the MOD, the first thing he was told by somebody was that it was being considered as possibly a malicious leak, and that, you know, a hostile state actor, potentially Iran or Russia or the Taliban, could be involved. That's what they were looking at initially. Obviously that was then ruled out. But we never got to the bottom exactly of what had happened, other than that, you know, I believe it was a mistake by a soldier, right? I mean,
yeah,
and personally, I wouldn't blame that soldier. I mean, we all sent an email in error, but there was obviously a systemic problem that caused.
But no one ever considered that it might have been that soldier doing it deliberately, is my question.
No, I think I had sort of throughout quite early on, I found out what had happened, I think, and I knew that it wasn't a malicious. Well, from my sources, from what the problem was is we couldn't ask a lot of questions because obviously we were bound by the terms of the super injunction. So we could only speak to people that we also knew about the super injunction. And I was led to believe quite early on that it wasn't a malicious act, and it was somebody that had done it by mistake in error, and that person was actually really trying to help the Afghans, and there was a mistake done.
Right.
We didn't have the details.
Thank you very much.
Yeah.
Right, let's continue delving further into the super injunction with my colleague Alex Baker.
Thank you, Chair. So we're going to delve into some of the detail now. So what do you think each government got right, and what should each government have done differently in respect of this legal process? Who would like to start?
I would say, I think initially the right approach was secrecy. I think that it was obvious they were dealing with a monumental blunder. There were lots of unknowns. There were huge numbers of lives at risk, and I think that was right to start off with a secret process. I think Larissa's completely right, and she made this point in court to the judge, that when we got to the general election, the judge was saying that the super injunction should be lifted. The special advocates, remember, they're the KCs who are security cleared, they've seen all the secret material. They were saying there was no justification for it. That's when I think that there should have been, that was the inflection point where the government should have realised that they needed to abandon their stance on the secrecy. Obviously then we had a change of government, and pretty much business continued as usual to begin with, until we got to November the 11th last year, nearly a year ago, when we had a slightly different change in tactic by the government, which I can go into great detail on, but it's essentially that they changed the mood from one of we must have complete secrecy to You, the press, need to remain silent while we, the government, release selected cherry-picked information to the public.
So was that October or November? Because there's a HEA meeting.
There's a HEA meeting in October, correct, and then in November we had one of our hearings in which we learned the detail of that meeting.
Thanks.
And is there anything either of yourselves would like to add in terms of what the government got right and what they didn't get right?
I personally think that the exercise of rumour should have been done far earlier than it was, because, yeah, I think it's a question of we need outside expertise to assess some of these issues, and I think rumour did do that exercise without disclosing key information. So stuff like the general picture of risk in Afghanistan is something that I think you need to establish with, people like the UN, try and get that sort of expertise in from the minute this happens, really, personally. And there wasn't really a desire to do that. I think also we saw throughout the whole process in terms of response to the breach itself was very slow in terms of setting up a resettlement scheme, how many people you're going to help. Like, that was part of why we got involved, was that it took 4 months, 5 months from the breach actually happening to them turning up and saying, oh yeah, we're going to help 150 people. Just like, what? This is so slow. And we kind of felt compelled to get involved in order to kind of hold the MOD to account on setting up whatever it was that they were going to do. So I think part of that is due to the structures of government, how that worked. And, we would often find out that ministerial meetings would happen like just before we went to court, so that there would be like something to tell the court. So that kind of seemed to be an impetus as to making stuff happen. But yeah, I don't know how about, Larissa?
Yeah, so the super injunction, I think, was in place for far too long, and Healy, Secretary of State, should have ordered that review sooner, in my opinion, the RIMA review, because that wasn't ordered until I think it was January this year, was it? Earlier this year. That should have happened way sooner. And then in terms of the previous government, I mean, there were questions about whether there should have been a super injunction at all. In fact, Rimmer even said in his review that it might have essentially made matters worse because it increased the value of the data set to the Taliban. And some people I've spoken to would probably argue, well, did they need it in the first place? If they just had a story in the Daily Mail as a result of David Williams at that weekend, would it have gone unnoticed by the Taliban, and that would have been the issue dealt with? I don't know the answer to that, but when Ben Wallace applied for the injunction to begin with, he thought it should be a time-bound injunction, and what we had was an indefinite injunction, and we saw no end date to it.
Well, we will be going further into the RIMA review, so we'll leave the questions on that for the moment. Go on, Alex.
I'm interested in this idea that there could have been a different way of doing this, and actually, acknowledging, the lack of accountability that has gone on in all of this. Do you think that there could have been a way where, there could have been, provisions put in place, for the secrecy, but then, briefing, for example, the Intelligence and Security Committee, so that there was some sort of basis of accountability within the process?
I was really surprised that the Intelligence and Security Committee wasn't briefed. Obviously, that committee is designed to be able to handle the most sensitive matters, and in fact, intelligence from the Defence Intelligence Unit in the MOD. So we had this was raised in court, and the MOD suggested that they didn't need to be briefed. So I'd be really interested to see what were those discussions behind closed doors.
And then, obviously, as it stands, you were the only people that were left to actually make the checks on what was actually happening. What does that tell us about where the gaps in oversight are when governments take on unusual steps like they have done in this case?
Well, the Special Advocate argued that the democratic process was in the deep freeze, and that was true because you're right, we were the only people that were actually holding the government to account or trying to hold them to account. But throughout this process, we weren't allowed into the closed hearings. So actually, we were doing this with our hands tied behind our backs because we couldn't make well-informed arguments without knowing what the MOD justification was for the super injunction in the
And the
first
special
place.
advocates who did have access to all the secret material, they weren't making inquiries with people in Afghanistan or in the UK Afghanistan community that we would make. So there was nobody really, apart from the MOD themselves, who could check stuff out and know all the background. And that is a problem, that is a gap. And I don't know what the answer is, other than there should possibly be a rule that super injunction shouldn't last for any longer than a set period of time or something, in order to force them to come out and be a bit more open initially.
Thank you very much. Jesse Norman, please.
Thank you very much indeed for coming in, and thank you for your testimony. Just want to pick up some of the points in the legal process that was undergone. Now, Larissa, you've mentioned that there were private hearings, so there were reserved hearings, or hearings to which you were not admitted. So we're building a picture of hearings which are private but open, that is to say the defendants can be there, private but closed, that is to say secret information is shared. What is so striking is that it seems as though the judge decided in his own judgment initially, not on a petition, that this should be a super injunction, that it should be global, and that it should be indefinite. Is that true?
No, that's not quite right.
Okay, thank you. So if you can put us straight on it, I'd be very grateful.
As I understand it, he did indeed upgrade it from an injunction to a super injunction.
Right.
But it was never indefinite. The MOD had asked for 4 months in order to take some protective actions, rescue people. And it's just that after that 4 months, they asked for an extension. And then
So pause for a sec. So the MOD didn't seek the super injunction, the MOD sought the injunction.
That's true.
And
but with the caveat that ever since they got the super injunction, they didn't want to lose it.
To be clear about what the facts are. Originally, the MOD applied for injunction. It was then upgraded to a super injunction. They thought, oh goody, we'll reapply for a super injunction when it occurs. But originally, they'd only asked for 4 months.
Correct.
They then reapplied, and it was granted.
It didn't have to reapply, it just rolled on. Well, there were hearings, and the judge wanted to weigh up various things.
There are hearings, people are speaking to this from different parts. You're getting a chance to cross-examine the people coming in and speaking to the judges.
Eventually,
yes.
Okay. But it rolled on over and over. And in fact, the judge himself, in his judgment of May 2024, when he said he was going to lift the super injunction, made the point, I have to grasp the nettle. Otherwise, this will just go on indefinitely.
Okay, great. So then the High Court wanted the super injunction to be discharged, and the then Secretary of State appealed that. Have I got that right?
Yes.
Yeah.
Okay. And what was the reason why the government, in your judgment, chose to appeal at that point? And why do you think it was so keen that it should retain the super injunction aspect?
I think the obvious answer is they felt it was offering great protection to their teams operating on the ground, and no doubt it was. But in terms of why they appealed, I mean, we don't know exactly because the appeal court heard an entire day of submissions and I believe fresh evidence from the MOD entirely behind closed doors. We weren't in there, so we don't know exactly what they presented to the appeal judges. But obviously by the time we got there the next day, it was obvious that the MOD had given a very convincing case. But taking it at face value, it's because it was offering protection for their teams on the ground. It was, of course, right in the middle of a general election campaign.
Yeah, okay. I mean, the decision was made before the election was called. The judge had no reason for thinking the election was going to get called.
Hang on. The May 24, when was the election called?
It was
May 24.
It must have been
early
called
June.
in May.
Early June.
Yeah, early June, was it? Okay. So, yes.
I mean, I don't think this. Sorry, there was a slight suggestion there might be political.
Yeah.
We knew it was
influence,
coming.
I don't think we can. I think we can discount any political suggestion. The judge wasn't being influenced to either way by any politician in relation to the general election.
The judge.
No.
Okay.
No, that wasn't a factor. The only, if you wanted to say there was any political interference, it would have been about whether or not to have an appeal, not the substance of the appeal.
Right. Okay. So they had an appeal and it was successful. They then didn't appeal it further to the Supreme Court.
They meaning the press.
That's right.
Yes.
You didn't, I should say.
No, we didn't.
And the question is, why is that?
I'd say a number of factors. I mean, some of it was legal advice that we can't discuss, but it was also...
Grounds didn't exist. It looked good in law, as it were. There was no arguable case to be made in the Supreme Court. That'd be the kind of argument.
Yeah, I think and of course we hadn't seen any of the evidence they'd given to the appeal court judges. So how are we supposed to fight without? We would be going in totally blind.
Okay, brilliant. And then just a couple of other quick things. So obviously they then, before this, it's already been, the super injunction has been extended to cover this secret settlement, this new settlement regime, the ARR, if I've got that right, with potentially enormous further costs. So there's a significant expenditure of public capital being covered by the by the super injunction, as well as all of the proceedings designed to protect individuals in theatre. Is that right?
Yes, billions of pounds.
Yeah.
And you see that in some of Chamberlain's judgments. He's starting to think, how is it actually possible to keep this huge process secret?
Right. There's an enormous machinery of government going on around the ARR, which is being kept secret by the super injunction alongside all the other materials.
Yes.
Yeah.
Okay, thank you. Final point would just be to note a point, which is we have detected a change within this committee. I think it's public record in the quality of information we've received from MOD, which has not just got worse, but has become structurally worse in the channels that they give us. And I've questioned the Secretary of State on this issue, and I've no doubt, without putting words in the Chairman's mind, it'll be something we think about in future. So thank you for your remarks about that. When the Secretary of State appeared in front of us, just for information. So thank you. Thank you, Chair.
Thank you very much. Okay, let's now move on to the impact of secrecy with my colleague Fred Thomas.
Thank you, Chair. Secrecy is quite a burden to have. You had that for a long period of time, which you're used to as journalists because you protect your sources, so you have some element of secrecy anyway. The judge in July of this year, in the judgment, said that it was a remarkable feature of this whole situation that there had been no mention in the media of the underlying matters for the several years that the super injunction remained in place. Larissa, you've just mentioned earlier, I think, that maybe he got that wrong because you were able to allude to a national security incident when asking General Jenkins a question. However, notwithstanding that, the judge thought it was remarkable that despite a super injunction, none of this came out in the media.
That was approved, by the way. The MOD said we could write that. That wasn't me trying to breach the terms of it or anything like that.
No, that's clear, and that's on the record. That's on the record.
He did say that. It was words to the effect of he was astonished that we'd kept our traps shut for 2 years.
Yeah, so my question to you is this. Do you think he means he's astonished that you, the media, kept your traps shut, as you say, Sam? Or do you think he's alluding to parliamentarians, where we as MPs have parliamentary privilege, so under the Bill of Rights, you can't put an injunction on us? Well, I wasn't there at the time, but the previous Parliament. Do you think that he's alluding to that and surprised that no one in Parliament raised this?
No, in his judgment, he was specifically talking about the media. But, elsewhere in the case, he was certainly incredulous, I would say, at various other aspects of what you're talking about, which is why Parliament was being kept in the dark. But, keeping that secret for all of us was very hard. And as Larissa said at the beginning, the hardest part was when we were speaking to Afghans, and Holly, I'm sure, had exactly the same experience, knowing that they were potentially in danger, but we were unable to ask them if their names might be on a list. We couldn't say there had been a list that had been leaked, that their details may have been lost. These are people who were being raided by the Taliban sometimes. They had family members being rounded up, and we simply weren't able to warn them. We weren't allowed to warn them. And that went on for nearly 2 years. And that was very difficult. My colleague David Williams says, since July, lots of translators have said to him, why didn't you tell me, David? My mother was beaten. I could have done something if you told us. And it was very, very difficult to keep that secret.
Must have been hugely challenging. Yeah, Holly, do you want to touch on that? Give us a sense of the professional and emotional strain that the super injunction put on you guys as reporters.
Yeah, it was really tough. I think initially when I first got served with the injunction, I kind of thought, I'll put examples to the MOD and I'll try and email them with cases, is this phishing email because of this leak, this person's had this happen to their family, and I would try and email them and say, can you look into this? And then that quickly became apparent that they weren't going to do anything with anything that I was emailing them. So I kind of stopped doing that. There was a bit in the initial part where, because I kind of got into this because they were evacuating some people, and there was a process I found really stressful where they gave people eligibility and then took it away. And, knowing the background to all of that was really hard when you're trying to raise people's cases, but then you're also thinking, I don't want to raise certain information. If it's information that's been shared with me privately, I shouldn't share it. But so there was a real tension of I don't want to share a lot of stuff in a court case that they don't know about, but how do I represent their interests? And how do we kind of raise their voices in that forum, because that was lacking in this whole process. I think, touching on what you said about kind of Parliament, I think the judge, particularly with Parliament, became quite concerned about the use of parliamentary statements being made to provide cover. So there was an instance where the Secretary of State made a statement to Parliament to provide cover for the secret scheme that was happening.
What do you mean to provide cover?
So essentially, he gave an update about the Afghan settlement schemes and the plan to close them, and that was to provide an excuse for the MOD to explain to councils, for example, why there's suddenly people arriving in their area. And so a parliamentary statement was used to explain, we're merging the schemes, it's going to be called this, and therefore that's what we're going to use to tell councils and MPs what's happening. And that was submitted to court. This is our plan to provide cover by using this statement. And that was something that I know the judge was quite shocked about when it happened.
That was the time that I was saying he was incredulous. I mean, I've covered the royal courts for nearly 30 years. I've never seen anything like it. You've got to imagine we'd had a year and a half of complete secrecy. Public can't be told. We're under threat of jail if we tell anyone. You guys can't be told anything. All the meanwhile, select groups of ministers are meeting behind closed doors to sign off enormous sums of public expenditure to set in train a secret migration scheme, knowing, because Whitehall had starkly told them, that it could lead to problems with social cohesion. You had 10% of the new arrivals were expected to enter the homelessness system. There was a link to last summer's riots, health, education, all of that. That was all going on. Yeah. With no parliamentary scrutiny at all. And that's when the MOD suddenly announced in court that they had this plan to, as Holly says, make a statement to Parliament.
And that was when?
That was November. Well, we found out about it on November the 11th last year in court, when the MOD, and Holly was reading from a document the court was shown. And what it says is, this is from the MOD, and it says that, so we've gone from total silence to suddenly the MOD saying, well, we're going to fill the void with some selected facts, which I thought was a sort of Orwellian leap from the original purpose of the injunction.
This is the statement in Parliament you're talking about.
And it was the statement in Parliament that said, we're going to make a statement which will be made to help to provide cover for the numbers arriving and, quotes, to control the narrative, but without, to set out the scale but not the cause of the challenge. So they were, I mean, all these things are total bread and butter issues for the House of Commons. You should all have been debating this. But instead, they had this idea that they'd put this this statement to Parliament, and you know, with no one being told. Now, this is when the judge, I say, was incredulous, because, you know, it was, and our QC was very good. He said, our KC, Jude Bunting, who's fantastic, he said to the judge that the MOD was deliberately misleading Parliament by omission, because they were going to make this statement but not tell the full facts. And that's when the judge himself highlighted that this was political, to use his words. He said that the statement to Parliament was to provide cover, as it is put, for the political consequences of bringing people to the UK by a statement that does not tell the whole truth to Parliament. And the government's response, their eminent KC, said, was reduced to saying the statement would tell as much of the truth as possible. Well, when the statement came in December last year, John Healey, it was a written statement, and, you know, he talked about there being some 90 Afghan families, and, you know, had we not been gagged, we could have told MPs that at the same time in the court the MOD was talking about some 40,000 Afghans.
Okay. Wow. I believe my colleague Deg Twigg wanted to come in on these issues as well.
On this issue, are you suggesting that the sensitivity around small boats, asylum, people coming to this country legally, coloured the government's view about how it was handling this?
No.
No,
Do you have a view on that? I mean,
I think it had an impact on accommodation. I think that was a big, I guess, logistical issue for them is, right, so we're bringing over tens of thousands of people. The current pipeline for the Afghan schemes is into more settled accommodation, but if you're bringing in tens of thousands of people, you're going to start have to using hotels, and I think they were aware of the political sensitivity of using hotels. But I think, but I think that's the only way it came in. It was kind of, okay, we've got to plan for the accommodation for people coming in, and what's the impact of that going to be?
They were worried about that though as well, because they were worried about explaining, you know, why all these people are here, and making clear that there was a difference between Afghans that might have come here illegally and Afghans that obviously were being given sanctuary because they served alongside British troops. And I think one of the reasons they needed to do that statement is to make clear that they're still bringing Afghans, but the statement actually didn't clarify which schemes were going to close. They didn't mention, obviously, the secret ARR scheme, which was set up in response to the leak.
Okay, so in terms of, again, within the scope of this misleading Parliament and what you said so far, we won't get into the Rimmer review because other colleagues are coming into that, but at what point do you think, because I think you said earlier on that you got the fact they had the original injunction in place, they understood why that was in place. At what point do you think they should have lifted that and come clean to Parliament? And how would that have helped or not helped the people who couldn't possibly been, you know, picked up by the Taliban, for instance, you know?
I think they should have done it
in this context of what
the obvious time to have done it was when the judge had assessed, he'd done the balancing act and weighed up the pros and cons in May 2024.
Yeah.
That was the time to have stopped their battle, as it were.
Yeah.
And obviously, it's going to have a huge effect with it. They called it break glass, the moment when...
So sorry again, because obviously you're more of the detail than we do. So at that point in 24, given what you said, that the judge said, and where we're at, why would the government then continue with it? What was the purpose for them to do that, if you believe there's an opportunity at that point to say, this is what's happened?
It's obviously convenient for them. I mean, it obviously was helping.
It's pretty convenient at some point, at any point in time, even now, it's come out now, you know, so...
Well, their view changed very substantially,
right,
both on the assessment of risk and on the assessment of how far the data had spread.
Yeah.
So when they appealed the decision, that their position as of now was definitely not their position. Yeah. So
you feel from what you knew, and obviously what the judge says, that actually that risk had changed, but the government didn't feel the risk had changed.
Their argument at that point was that they're still trying to bring Afghans out who were on the list, and therefore if we reveal the existence of the list in the media, then you're alerting the Taliban to the fact that there is a list out there, and then the Taliban could try and get their hands on the list, and they believe that the Taliban might be able to get their hands on the list. So that's why they argued in court that they were continuing it, because they thought it was a risk to the Afghans.
Then you would have thought then a new government comes in July, there's an opportunity. Why didn't they take it then, do you think?
I imagine they were being briefed by MOD officials that it's really helpful to us to have this super injunction because we can carry on with the rescue evacuations without anybody knowing about it, and it just is easier, I assume. But I mean, they'll tell you that.
But then in October they decided to change the tactics in terms of having a narrative rather than just keeping it secret.
Because it got so big. I mean, they were bringing in thousands of people. I mean, I stood
£7 billion.
When I stood at Stansted Airport watching these unmarked planes arrive, and on one day there were 2 that landed, and these planes land at Stansted. Instead of turning left to the passenger terminal, everyone loves and loathes in equal measure, they goes right to the private hangar, where it got enormous, and local authorities were having to deal with all of this. I would see a report on the BBC, and Holly pointed to one in local towns were having unrest problems. There were military barracks where hundreds of people were being brought in, and there was no explanation to local communities, and it was causing a strain. No one could tell the truth.
Back to my original question, saying was that part of the narrative in terms of the worry about the issue around immigration?
Yeah, so they felt like they had to say something, but they were stuck because they couldn't tell the proper story.
Right. It's a bit also new ministers being caught in headlights type of thing, what's going on here. Is that?
I'll just go back to what the judge said about grasping the nettle. He said this would go on indefinitely because they'll just keep saying it's useful to carry it on every 3 months, forever. And how long is this evacuation scheme going to last for? I mean, they've shut it down to new applicants, but of course they are still going to honour the offers made, and that will involve the operations on the ground going on for quite some time, I should think.
Yeah.
It was also a law firm became aware of the super injunction, and I think that sort of changed the thinking inside the MOD to some extent as well. They realised that it could no longer hold because Afghans were being signed up to sue the government.
Do you think of it throughout the, and I'll just come to a conclusion in a minute, in for previous government to this government, that the issue about misleading Parliament and Parliament being kept in the dark was never the main consideration in this?
Well,
I mean, it came up at every hearing, right from the start.
I'm talking about ministers, yeah.
Yeah, well, I mean, Grant Shapps, the former Secretary of State, we know from the court papers, was, advised to tell the Speaker, to tell John Healey, then in opposition, and of course the Intelligence Security Committee, and he said no, and the judge was very unhappy about that. You could tell, and eventually they did brief those people.
They didn't brief the IC.
Not the IC, but they did brief Mr. Healey and the Speaker.
Okay, the final question is slightly different. It's just, what are the issues, and again, I suppose if we're looking at the way the MOD works, the timescale from when the breach happened, when the mistake, what do you know about when senior people were informed about this, or ministers were informed about it? What do you know?
It's not already in the public.
It's not already in the public domain. Do you?
I think
Wallace found out very soon. Was it the 14th or the 15th?
Yeah.
The 14th, the balloon went
But
up.
there's no evidence that they knew before.
No.
Then. Yeah.
Oh yeah,
No, that whole 18 months, nothing.
Okay.
Thank you much, Fred Thomas.
Thank you. Just again about the secrecy and information. So super injunction's been lifted. Most of this is out in the open now. It's not all out in the open. There still is an injunction, and some things are covered by that. And I want to ask you about that, but obviously just to preface, we don't want you to say anything you shouldn't, conscious that there are lots of things you can't talk about. But what I did want to ask was, maybe you can comment on the significance of what's not out in the public and what's under injunction, or how the public might react if that information was public. Are you happy to do that in any way?
Yeah, we can talk.
Yeah, I mean, I don't think it's anything that dramatic. It was lots of details. Some we can talk about because there was a whole hearing where we had to argue about what we'd like to say, and in most cases we lost, but in some cases they allowed us to. And one example of that, which I'm allowed therefore to talk about, was the in the early stages, the MOD were trying to think of ways to deal with this problem, and one idea was to beg favours from Britain's allies to see if any would take some of these data-affected Afghans. And the USA was one of the allies. When it came to reporting this story, the MOD wanted us to censor the words USA from the reports. And this was argued in court, and eventually the judge said that we could say the USA. And the reason they didn't want us to say it was, in their words, international relations. And so I think the judge took the view that that was more a political or a diplomatic reason than a national security reason, and he allowed us to say things like that. So there are examples like that. And there was another one we thought of. What was it?
It was negotiating with the Taliban. So it's probably helpful to just explain that we had like a 1,500 word page bundle, and we had to go through this painstaking process with the in court to determine what we could reveal from this bundle and what we couldn't. And so we were arguing that we wanted to be able to say the US part, and we also wanted to be able to say that there was a part that was headed negotiation with the Taliban. Now, the rest of that was blacked out, so we don't know what that included. We wanted to just be able to say that they were discussing negotiating with the Taliban, and in the end, we won that as well. But there's obviously all the stuff that was held in the closed hearings, we don't know what was said, and the public doesn't know what was said. Then there was hearings that we had discussions about matters about informing Parliament and various other things that we can't tell you about because we haven't had approval for those documents and discussions to be released, and the transcripts that were in court. So we were going to the government and the MOD, well, the MOD and the courts, to say we want to reveal this quote was said in this hearing on this date, and this was all happening in the final days before the super injunction was lifted. So we had to get approval for every single sentence. It was, it was
and Larissa, what's it,
mammoth task.
I mean, that sounds like an epic task. Those things you haven't been able to share. So, for example, the discussions around disclosing things with Parliament, the direct quotes that you haven't been able to share. Do you think the public would find them shocking, or not?
We don't know. Who knows for the closed evidence? I don't know. We don't know. The rest of the stuff, I don't think it fundamentally changes the story now, but I think at the time it would have been helpful to be able to say those things.
Thank you very much. Let's now move on to the issue of risk assessments. And to kickstart us off, Emma Liu, please.
Thank you very much, Chair. Morning, everyone. I just want to touch on the RIMA review, because I'm struggling with, based on the evidence that we have before us as a committee, how the risk assessment moved from August 2023 to individuals being at risk of death, to then November 2024, secrecy still being needed to protect life, and then June the following year, there was a diminished risk to individuals. Do you feel that RIMA was a fair and accurate assessment?
All I would say on this is they stopped relying on the defence intelligence assessments, and there weren't any defence intelligence assessments in the sort of immediate period leading up to the RIMA review. So that, I would like to know more about that, and I'm sure that's something that you can delve into, but I know Holly has something to say on the RIMA review.
Yeah, I think it was a useful exercise in terms of going to, and I think, if you want to dig into the RIMA review, I would suggest going to these organisations yourself as well. So going to the UN, going to Rawadari, who are an NGO that do a lot of documentation of reprisal attacks. I think it's useful to have a picture of, what are reprisals like in Afghanistan, who is affected by reprisals. And so I think that exercise is useful. I don't know whether we kind of got a sense of what the defence intelligence assessments were through what people said in the hearings we were allowed to be in, but we never actually got to know what was in the defence intelligence assessments. Mm-hmm. So we ourselves don't know, the substance of those assessments. But I'm not sure it did the same. Obviously, RIMA did a different exercise in terms of being able to get that expertise from outside. I think, lots of people who submitted evidence will have different opinions on whether that was a correct assessment of risk, whether that reflected enough the specific risk to Afghan security forces who are connected to the UK. So I'm sure you'll hear different views on that, but I would just recommend, if you can, trying to speak to UN Special Rapporteur or Rawadari to try and get a sense of that overall picture, because I mean, I try and do a lot of documentation of reprisals myself, but it's by being a journalist, you're dealing with anecdotal evidence. Obviously, you're trying to tell individual stories, but it's harder to get that kind of nationwide picture in the same sense. So I think, if you want to kind of dig into risk, then I would recommend doing that, really.
Can I just ask Holly, on the back of that, why do you think RIMA didn't look more deeply into reprisals?
I think he did. I mean, I don't know, I can't speak for him, but I think he did deal with that issue because he spoke to these organisations, I think, or he definitely relied on some of their reporting. And he also spoke to like Person A and some of the caseworkers involved who have really detailed knowledge of specific instances. I think the issue with reprisals, as I found from trying to document them myself, is you can document what happens to a family and you can document a killing and you can document a death. Individuals don't necessarily know why that has taken place, right? And so it's really very difficult to draw a direct link to this specific data breach, even if this specific data breach has resulted in death or reprisals. It's really hard to like directly prove that, if that makes sense. And I think that's the problem I've had with like trying to tell individual reprisal stories, is it's hard to go beyond the circumstances of what happened and figure out, well, why is it that happened to that individual? Lots of people have different reasons, as like families have different stories. It might be people came from out of town, it might be they feel that someone within their community has like told someone else about their previous service. It's very varied in terms of like, trying to figure out why things have occurred, but I would recommend you investigating that.
What he did, though, he could have done far sooner. You didn't need to wait until then to speak to those people. And actually, one of our frustrations throughout was that we were speaking to somebody who's named as Person A, who I think might be giving evidence later. And she was saying that she believed that the Taliban already had the list and was going through the list, killing people on it. And we were just surprised that the MOD didn't want to question her further. And I think she was, in the end, questioned about it, but that took too long to speak to people like that.
Yeah, and this is kind of what I was saying earlier, like we would send in examples of a phishing email or, things that Person A had said, and they wouldn't follow the steps to try and speak to that family or investigate that thing. I mean, we did do, towards the end of the process, we did give them a bunch of names of people who had been killed in reprisal attacks, and they then cross-referenced that with the database, which wasn't that useful because basically I think a lot of the names they couldn't, like spellings and stuff, I think the exercise, I mean, there was 17 people, I think, from memory, who we gave them like 250 plus maybe names, and they identified 17 who were on the database. And 14 of those had been killed after the data breach had happened. But yeah, I think they came back with basically, we've struggled to match up the names with issues on the database.
Just wondering how you would reconcile your view about lifting the super injunction with continued reprisals. That must be quite...
This was, for me, this is quite crucial, because obviously the ministers had a different argument. My belief was that it was the right of the Afghans to know that their name was on that list, and therefore, if they knew that, they could move house, they could change their phone number, they could tell their family members to flee. They should know that. It would have been. I felt that was one of our arguments. Now the MOD decided not to tell those people for 2 years. So for 2 years, at any point, the Taliban could have suddenly got the list. And also just to point out that the MOD admitted that there was a possibility during this time that the Taliban did have the list. They didn't know. It was all based on probabilities. And so, therefore, I thought they were gambling with death because they knew that there was a probability, there was a chance that the Taliban had that list and were killing people. So that was my view throughout, is that the Afghans deserve to know.
And that was something the judge was very good on as well. He had this idea all the way through that we don't know if the Taliban have the list or not. And if they do have the list, then the super injunction is making life much harder for Afghans who are on the list, because the Afghans themselves don't know about the data breach, that the Taliban have the list. And he said in one of his rulings, one thing that can be said for absolute certain is they'll be far better off learning about it from the British government than from a knock on the door from the Taliban.
You know, at the point when the assessments were made that the super injunction relied upon, was that being said then that the Taliban could already have the list at the point when it was put in place?
All the way through the case, they didn't know. As Larissa says, it was all based on probabilities. They just didn't know whether they had the list or not.
And these defence intelligence assessments, I think you said you've never seen them or weren't privy to those. Do you know if that was being refreshed regularly throughout these years? Do you know who did them? Do you know how many assessments were being done? What was the process?
We also we put all these questions to the MOD and they didn't answer. Because I was interested to know, who is it? One person? Is it lots of people? Is it a department? Are they specialists? Are they not specialists?
We want to know.
They did get updated.
We know some detail, but actually I'm not sure what we can say.
I'm just having that thought.
Sorry,
there may be. We were never told their processes. We were told some of their conclusions, but we would have to check whether or not those were redacted. I can't remember offhand.
We wanted some details published, and I don't know where we got to.
But I mean, ultimately, it was a very opaque situation for us, and most of the evidence on that was heard in total private.
Okay. All right, I'll leave it there. Thanks.
Thank you much. Calvin Bailey.
Thanks very much. So I would like to try and explore and answer the question, who should be held accountable for the data breach and for the government's response to its discovery. And in doing so, I'd like to consider if individuals are at fault or if we're dealing with good people responding to the best of their ability to deal with a series of unfortunate circumstances. And I'm going to lean quite heavily on the evidence. I hope you've all seen the Public Accounts Committee, in which I questioned the Permanent Undersecretary about this. He has issued a letter and a response which covers some of this. And I'll put to you, perhaps, that the responsibility for managing the recovery of UK citizens overseas is a non-combatant, as NEOs, as we know them, combatant evacuations, and that is principally the responsibility of the Foreign Office, as detailed in Joint Defence Publication 3-51, which is the government's own document on non-combatant occupation, evacuation. So let's perhaps start there. Who is responsible for this breach?
So obviously there was the individual soldier that sent the list twice in 1 month by mistake.
Okay.
Now I think it's much bigger than that individual, and you know that person, I've been told, was really trying to help the Afghans and work out exactly who should come here and whether their applications were truthful and whether they had served with the British military. So I wouldn't say that person.
Okay, so we accept, and we've seen, that individuals make mistakes, and their ability or their propensity to make the mistakes is based on the position that the system puts them in, right? So that individual was in the MOD.
Correct, and he's been moved from dealing with the Afghan cases to somewhere else in the MOD, and he hasn't been sacked. But in terms of when you look at it, then why did that happen? I know that, my understanding is that Ben Wallace, after a previous data breach, had asked the department to make sure that if they're sending any data out of the MOD, that should be checked. So who was supposed to be doing that process, and why didn't they do that?
Okay, so in his response, they recognise, the Permanent Undersecretary, David Williams, recognises that the breach was made by an individual, and as you've described, we're not going to lean on the individual because they are a subject of the surroundings that they're placed in. We know that they've inferred that this is a lack of appropriate systems to prevent or mitigate the error. And all of the discussion has been about this taking place within the Ministry of Defence. What I'm putting to you is perhaps, is it reasonable that this takes place within the Ministry of Defence and not the Foreign Office?
They were the lead department.
Why?
And because this all started with the ex gratia scheme and then ARAP, and I mean the Daily Mail's been running this campaign for 10 years, Betrayal of the Brave, to try and help people get sanctuary in the UK who had fought or served alongside soldiers.
Why is that the responsibility of the Ministry of Defence?
Well, because they were in the large part military interpreters that ARAP was set up to help rescue, and so that scheme began. I think the MOD's been behind at every stage, playing catch up, and Operation.
Is it reasonable? What I'm asking from you, and I'll come on to some of the comments that you've all made. Is it reasonable? The Foreign Office is responsible, so an individual's eligibility will be determined by the FCDO and the Border Force. Everyone is focusing on the Ministry of Defence. Does it seem reasonable that the MOD would have a caseworker system to deal with?
Yes, because the whole point is the reason that this soldier leaked this list is because he was using the knowledge inside the military to determine whether these Afghans had served alongside officers or soldiers from the British military and whether they served alongside our troops. So you needed MOD input, and that was what he was doing at the time.
They needed that, but if you're saying, was it right that it was the MOD that was in charge of this database? Not necessarily. I mean, I would say the person responsible is whoever came up with the idea, let's put all the data in one Excel spreadsheet. And so why didn't they have a much more secure system for managing the data? That's who should take the blame for this. And whether that would be an MOD system or a Foreign Office one, I don't know how government works, but certainly that would be where I would look.
Brilliant, and I agree with you entirely, and that's why I put to PUS that actually the failure inside the MOD was to aggregate this data in the first instance, because that is a breach in and of itself. Large collections of data and mixing data of various kinds is a breach. So regardless of whether an individual pressed send, there was already a breach there. But the point I'm trying to explore is whether it is reasonable for the Ministry of Defence to act as a caseworker. That is the responsibility, in the MOD's own documents, of the Foreign Office. So where I'm trying to go with this is to understand, was it the fact that the Foreign Office failed to do its job, or was it that the MOD was too willing to accept something that it wasn't capable of doing?
Yeah, I mean, the reality, why it got set up, but I mean, DA exists as essentially a case-working unit. Why that has happened, I don't know. Why it got put to the MOD to do that, but obviously this whole unit exists to essentially assess Afghan resettlement claims. And yeah, you could question, should that be the MOD running that? But I guess the reality we are at now is that there's this whole department that is full of caseworkers under the MOD who do all these kind of resettlement assessments. Yeah.
It's always been with the MOD as well, since 2015 when I've been reporting on all the schemes. It's always rested with the MOD because, as Sam said, it started off with Afghan interpreters and then grew and grew and grew. So it just seems to make sense that you would continue to keep it within the MOD in some form.
So your premise, your understanding is that this is an MOD responsibility rather than the Foreign Office.
ARAP is.
The management. So the management of the eligibility of people to come to this country, caseworking, is an MOD responsibility.
Well, it has become that. Yeah.
I mean, principally it is because they had to find out if they had indeed served alongside British troops or whatever it is they were claiming. Obviously, after they are given ARAP eligibility, if they are, it's then other departments such as the Home Office get involved to check on security systems and various other things to see if they can actually come here.
Okay, it's important. This is very important because it is FCDO has systems to manage casework because managing people is normal for it as an organisation. The point I'm trying to make is, in accepting this, the department, the Ministry of Defence, invited onto it stuff that it wasn't capable of doing. And I want to know whether it was the ministers or the officials that put that individual into the position where they made the breach, where they were not given the appropriate equipment, training, the department that has now been built and put in place, whether it was the ministers or the officials' fault for drawing their people onto that.
I think that's a question for the MOD.
Brilliant question.
Yeah.
We'd love to know the answer. I think,
and what I would also really like to know is, has anyone been held to account? Because if you speak to the MOD, they don't tell you that anyone has been investigated. I would like to know the answer to that.
And that's why I asked in particular yourself, Larissa, because in your articles that you claim the ministers were gambling with death based on probabilities. That was one of your quotes. Yeah. My view of this, for what it's worth, and you need to comment on, is why would you have the risk assessments, that the failure in risk assessment was the failure to realise that the 800 people that they thought they were going to deal with was circa 14,500 or in excess of that, and as a result someone was inviting that amount of pressure onto people that weren't appropriately resourced or trained in doing so. That is where accountability stops, not the individuals below them. And whether that is ministers or whether that is the PUS is of interest. That is germane for this discussion. That's what I'm trying to get after.
Yes, well, yes. And what I found quite interesting is, we're not going to give our opinion on who should be held accountable personally. I mean, I don't know the answer to that, but one of the stories that I wrote, I mentioned Gwyn Jenkins. Now, I thought it was interesting that a minister at the time in Cobra asked Gwyn Jenkins whether he or Admiral Tony Radican, who was CDS at the time, were going to resign over it. So clearly ministers felt that senior military chiefs should be taking responsibility for it. Now, that's quite interesting to me.
It is, and also why someone would invite the responsibility. Do you see my point now? So out of those individuals or the PUS, and I've asked and I challenge you to go and look at the public accounts discussion on this, but someone has to be identifiable for inviting that onto their people, and we have to know the reasons for why they would choose to do so. Okay, thank you.
Thank you very much. Ian Room, please.
Yeah, thank you. Must be very frustrating for you as journalists not to be able to report this, and I want to focus right on something that you said right at the beginning, Larissa, about the general election period. And the Afghan Solidarity Coalition wrote at the time, the prolonged duration of the injunction raises serious concerns about the political motivations rather than protection imperatives. The length of this injunction conveniently covered all eventualities surrounding the general election, lose or win, ensuring no direct implications for MPs or ministers involved in the breach response. What impact do you think, and your perspective around that general election period, and the change of government, how did it affect your reporting at that stage?
Well, I think we'd be having a very different conversation now if the Conservatives had won the election, because then we'd be looking back at with hindsight at them blocking us from reporting this, seismic story. And yeah, I think we talked about it, didn't we? In that period, we were really mindful of the fact there was an election, and there was a lot of discussion about when the super injunction might lift, and we discussion in court about the fact that it needed to be before people voted, and then of course the government appealed that decision, so it wasn't necessary in the end.
And then fast forward a year, and we were having the same conversation about trying to get it lifted before the summer recess. And at one point, it was looking like it might conveniently be lifted sort of 2 days after the recess. thus denying all of you the chance to debate it in Parliament.
You got anything to add to that, Ollie, around the election period?
Yeah, I don't think there was anything. We obviously felt, obviously the election is looming, but there wasn't any sense that there was any particular political reasons as to why XYZ decision was taken. I slightly feel that any side would have appealed the High Court decision. It's kind of a natural legal next step. So, yeah, I think we would have always ended up at the Court of Appeal, probably.
I mean, the judge did keep saying, he didn't say this is political, but he did make the point that we're not talking about secret weapons programs. His exact quote was something like, "We're talking about a secret resettlement scheme for immigrants to the UK, and these are the political consequences of this scheme." He made that point. He was very clear to him, and this was just before the summer. This was just before. When was that? That was it was a year ago in November. So it was after the general election. But he was obviously, as I keep saying, incredulous about certain points.
So the Conservatives were in government. The election was called. The results announced that Labour were now forming the new government. What was going through your minds about this particular injunction at the time? Were you thinking that they should have acted quicker?
You spoke to somebody who wanted to get it lifted quickly. I remember thinking, from what you were being told, that they might have a complete change of heart about it. But they didn't, because then they had that October HEA meeting where they were talking about extending the scheme. And they were talking about, £7 billion of public money. I mean, it was very clear. Increasing the scope, increasing the numbers.
And it went on for a year instead.
Yeah, this is October. The current policy response to the data incident will mean relocating 25,000 Afghans and extend the scheme for another 5 years at a cost of £7 billion. So, there was clearly no particular change. If anything, it got deeper.
And given that, what's your frustration around the MOD not giving you the responses that you need now after all this time?
It just makes you wonder, has anything changed since that moment two and a bit years ago when they so alarmingly easily went down the path of an unprecedented act of state secrecy?
Thank you very much. Calvin Bailey wanted to comment on this.
I just on the back of that point out again at Public Accounts Committee. So just now you've all said billions of pounds have been managing this fallout, and you've just made reference to that. I put to PUS that a caseworker system costs £5,000. I think we pay about £1,500. And that is the risk decision that someone failed to make in 2021. So again, about responsibility, it's billions of pounds on defence. Should this have come from the defence budget, or should this come from foreign?
I don't think they'd worked out where it was coming from. They knew it was going to cost up to £7 billion, but that was taking into account housing and various other costs when people were actually in Britain. But they hadn't worked it out. There was no suggestion from any of the things we saw that the Treasury had signed this off, or that they knew which budget this was coming from. But of course, the Chancellors, both Conservative and Labour, were in these meetings. I mean, there were meetings of pretty much all the senior ministers apart from the Prime Minister. So the Chancellors would have been aware that there was a lot of money that was needed. But we don't know where...
The Chancellor wouldn't have been aware at the moment that someone who had an organisation that wasn't capable of handling this information had made a decision that was a £7 billion gamble on a failure to invest £5,000.
It's a very striking way of putting it.
And can I just come back and just say, publicly, have you ever been told that the MOD aren't now got personnel in there keeping things on spreadsheets to ensure that this doesn't happen again?
You've been told that, sorry?
No, I'm saying have you been told that they're not using this system of using Excel spreadsheets now, so this same issue and problem could happen?
They changed the system at some point, but actually I don't know the detail of that.
Right, okay.
I would hope that they're not doing that.
I hope they have as well, but I'm just wondering if anything's gone out there publicly about this.
Probably on Google Docs. You know.
I think there is something about them changing the system, but I can't remember the detail.
Right.
Yeah.
Brilliant. Thank you very much. In your evidence, you referred to a confusing disconnect. So saying that the government in court has presented a very different narrative about the number of Afghans to be relocated to the one that it presents today. For example, the narrative in court was that the cost would be up to £7 billion, and the number of people that we're dealing with could be up to, from 25,000 to 42,000, whereas the narrative now seems to be that the costs are up to perhaps about 850 million, and that it involves around 6,900 people. So, do you believe that there is an agenda behind this change in narrative? Who would like to go first, please?
I don't know if there's an agenda, but it just was very stark that when the government were arguing with the judge about keeping the super injunction, there was one set of numbers, both for the cost and for the numbers coming, that were very high. And then when large numbers, and then when the government was explaining to the public what had happened after the super injunction was lifted, these numbers suddenly shrunk to very small numbers. And I don't think we ever say that there was an agenda or that the numbers are wrong. It's just that they as far as we're concerned, they found it very difficult to explain it to us.
I also think it'd be quite hard for the MOD to tell because they didn't necessarily start recording. I don't think, this person's here under ARAP, but their risk has been reviewed as a result of this data breach. Obviously then you have the AR asking, which is more comprehensive, and they do have numbers for that. But I think, and especially with the money, I think a lot of it did get merged in the response. And so exactly what happened, exactly what numbers came when and which scheme they were under and what that then cost, I think might be a bit difficult for them to even figure out. But
it's more a case of confusion and chaos rather than some sort of ulterior motive or agenda. Ms. Brown?
At the beginning, they were only going to let in about 150 of the Afghans, and then they sort of decided who they believed would be at higher risk. Right. It's a bit unclear how they went from then 40,000 to 20,000.
6,900.
Oh yeah, and 6,900 at one point. I'd be really interested to know how they've decided who gets to come and who doesn't, because right. At one point they were saying like 40,000 people were at high risk.
Yeah. And also, it's the case that the Afghan Solidarity Campaign, they have written that they believe that there are political motivations behind this rather than actually the protection imperatives, which should have been at the forefront of how those Afghans were dealt with. What are your views regarding that?
It's really hard to know what the motivations are, but I genuinely think that John Healey and Grant Shapps and Ben Wallace, cared about the Afghans and what happened to them.
Right.
I think that didn't necessarily translate into speed of action, however, because, especially at the beginning, I definitely feel that the schemes were expanded as a result of this legal process. We kind of forced the MOD's hand to do stuff because of the legal process. I don't think if they were left to their own devices that this would have necessarily happened. It definitely felt that in the process, they were coming up with answers because of the legal process,
Anecdotally, you talk to Afghans and they can't understand why someone else has been prioritised ahead of them. It seems to be a bit of a mismatch there. I mean, if you go, I think the MOD have just always been very slow to get these schemes up and running. And, it took a lot of campaigning to get ARAP up and running. Operation Pitting was then a bit of a disaster from the point of view of ARAP people, because I think most of the 15,000 people weren't ARAP eligible. They were just people who, someone was doing a favour for somebody, or it was all very last minute and chaotic. And, people came who weren't necessarily the ones that you would have chosen if you'd sat down and had a proper look at it in the first place. And I think that's characterised the whole system. It's been quite hit and miss.
Right. Calvin Bailey?
Sorry, just to go back on this, can you think of another example, another non-combat evacuation that was run by people that don't do this as their job?
I don't know.
It absolutely bemuses me that no one has pointed out that this, if there was a NEO anywhere else, we wouldn't be talking about the Ministry of Defence. I get that some of the people, like the eligibility, some of the people had Ministry of Defence backgrounds, but what you've just said, like the fact this arrives at pitting, like this is a huge failure of foreign policy. This is the Foreign Office's job to manage and understand where UK EPs are in a country such that when an evacuation is called, they know the priority of those people.
I'm pretty sure though at the time of pitting, the Foreign Office had
On
people,
holiday.
well, I think they had people in country and then they were pulled out. And so the MOD then sent people to Afghanistan.
Yeah.
I mean, the troops who served during Operation Pitting, obviously they, were extremely brave and worked really hard, but there wasn't a concrete policy there. So they were allowing people into the airport that weren't on the list and then having to tell them to then get back out, and allowing people in that shouldn't have been there and not allowing others in. I mean, it was very chaotic, as we all know.
Right, brilliant. Fred Thomas.
Thank you, Chair. Holly, I just want to take you back to something you alluded to kind of a bit earlier in the session, but it comes from this discussion about the numbers and slightly unknown numbers from the MOD point of view of Afghans being resettled. And you said it's becoming much harder, it seems, to resettle people from Afghanistan here.
Yeah.
And you recommended that maybe we look into this and sort of ask some questions why. What kind of lines of inquiry do you suggest we take? What are some of the reasons that could be?
I would like to know, for example, how many people have been evacuated from Pakistan to the UK since this super injunction was lifted. And I would also like to know how many people have been moved from Afghanistan to Pakistan. I recently reported on a case of a family who were deported from a Pakistan hotel run by the UK back to Afghanistan. Obviously, the picture in Pakistan is essentially the Pakistan government aren't happy about this happening and continuing to happen. And we heard in the court case that actually they'd give until the end of 2025 as like a hard deadline to get this scheme closed by. And obviously, they're not keen on people without visas, because often the visas run out because people are waiting in these hotels for Home Office checks that take a long time. And so, I recently reported on a family that was then deported back to Afghanistan. So, and I've not been hearing of many people kind of going through that process, and that's quite worrying to me. And it might be that I'm, not getting access to the right pieces of information and I'm not speaking to the right people, but I think you could just kind of clearly ask, like, oh, do you have a figure? I mean, they might say operational reasons they can't disclose it, but maybe in private they could tell you, how many have actually been being moved through the process, because there's still people who are eligible for ARAP and eligible for ARR who are waiting and they haven't been evacuated.
Yeah.
So.
And yourself, Larissa, are you able to suggest any reasons we might look into as to why it's becoming harder, seemingly, from reporting, and there's kind of less of a willingness, it seems, on the UK government's side to resettle certain Afghans in the UK?
I think I was speaking to one of my sources last week in the MOD, and they said that the numbers had barely changed since the super injunction had been lifted in terms of bringing people here. So that suggests that they've hardly brought anyone at all. Immediately after the super injunction lifted, they did have at least one flight that came here, but then since then, possibly no flights. So we're unclear, so we want to know how many flights have come here since, how many people. They should be able to tell you those figures. They told me that those figures, they've told me them before, so we should have an updated figure.
And you've reported, Larissa, I think, on the MOD saying that they were reviewing some cases of rejected applications from certain Afghans.
Yes, it's quite complex, but I mean, some of the Afghans that they've allowed as far as Pakistan, so they've told them they can come to Britain, they're eligible, subject to Home Office checks. They then go to Pakistan and they can wait up to 2 years in the hotels. This has happened in at least one case. then to be told that Home Office, they haven't passed those Home Office checks and they'll be deported back to Pakistan, and that has actually happened. And
Back to Afghanistan.
Back to Afghanistan. And that
And do you put that down to kind of bureaucratic incompetence, or do you think that's deliberate?
I think that's bureaucratic incompetence. Yeah. I mean, it's shameful, really, that you could allow someone to live in a hotel for 2 years, thinking they're going to come to a new life in Britain, then deport them back to Afghanistan.
It's certainly shameful. I'm just wondering whether it's incompetent or deliberate. Sam, you look like
I don't know the answer, but I'd love to know it, because it's very convenient, isn't it, for the government? Because they've said that the numbers are much lower now than they were telling the court, and the key question is, well, why are they lower? How have you achieved that? And obviously we've got this situation where huge numbers who have been waiting in Pakistan, believing that they were coming, are now being sent back to Afghanistan, apparently because of something. But they won't say what. But I mean, you know, Home Office checks would be one answer. But I mean, is it really true that all of those thousands of people have suddenly all failed Home Office checks?
There's also people still in Afghanistan that have been told they can come to Britain, but they're waiting in Afghanistan as well.
Yeah. And Larissa, when you reported on this, you, I think, specified that some of the cases that were being reviewed, who had been rejected, were from Afghan Special Forces. Is that right?
Yes, I think this is about the 6 of them. The 6 of them, one of them was an interpreter, and a lot of the cases are about the Special Forces, the Triples, but I can't remember.
There's separately to these, gets confusing, but separately to all of this, there's the Triples review, which is looking at where it was originally looking at 2,000 applications of Afghan links to specialist units, and reviewing rejections due to failures in the way that their cases were specifically handled. That's still ongoing, and they added a whole bunch of new cases to that a few months back. So yeah, that's kind of a separate arm to the rest of the resettlement schemes. And
yeah, I mean, from some perspectives, it's not so easy to separate them, because ultimately we are talking about, you know, people from one country, and are we able to resettle them? But I take your point.
And a lot of them are data affected people, right? So that also comes into
There's an overlap.
Yeah.
Yeah.
And the MOD will say, we're bringing these people as a result of the Triples review, but what will be quite crucial is to note how many of those people were on the data set and that might not have come otherwise.
This
You're
is
right,
when
we
don't know.
We won't know,
Yeah. Okay, thank you.
Thank you very much. Right, let's delve further into the resettlement aspects with Ian Rowe.
Yeah, given your connections and knowledge and experience, particularly your connections in Afghanistan, put simply, was the government justified in its decision to close the resettlement schemes to new applications in July?
No, because not that we didn't expect them to close at some point, but what's happened is there are plenty of people who weren't aware that they were about to close and who needed to reapply for whatever reason. You know, for example, they may have had their original application just may have been lost. They may have had their homes raided by the Taliban. You have one email address, one phone number, and if your home is raided, you know, the advice of the British government is change your number, destroy your documents to keep yourself safe. But as a result, you then need to reapply. And there are a lot of people who would have reapplied, could have reapplied, but now can't. And so, yeah, sure, the schemes obviously were going to end at some point. We knew when we campaigned to set them up, they wouldn't last forever. But to do it now does seem slightly unfair.
It was also the fact that they didn't, it happened on that day. We were told basically in the morning that it would close at 3 o'clock, I think it was. I mean, surely you should give people more notice.
And I asked the MOD, and they didn't reply until after 3 o'clock.
And they didn't update the website until after 3 o'clock. I think it was still saying that you could still apply even when you couldn't. There was, it could have been handled a lot better, I think.
Yeah, thank you much. Right, Alex Baker.
Looking at the whole course of the resettlement programme, across the whole piece, what did each government get right and what should it have done differently when it comes to the resettlement programme?
So over the decade, you mean? Or,
exactly, yeah.
So I've been reporting on all the schemes since 2015, maybe even 2014. And I was at the Daily Mail previously, and I was running the Betrayal of the Brave campaign with David Williams. And we, initially the Afghans could only come if they served for a period of 12 months in Helmand province, and then were made redundant. And that was sort of a very narrowly defined criteria, and we argued that should be widened. They also had a separate scheme where you could come if you had been intimidated, but then a lot of the Afghans had got evidence of intimidation, but then they were being rejected. So from the beginning, it was a very ungenerous policy, and we managed to get that policy changed several times over the years. Firstly with Gavin Williamson, who changed it marginally, but then I sat down with Ben Wallace and Priti Patel, and they changed it in a sort of more in a better way to bring in more Afghans. But overall, throughout all the years, it's been really, really difficult. And I feel like that, it's been cruel at times where Afghans have been able to come, but then not bring their wives and children further down the line, and they've been separated from them. And you've had Afghans be told they could come here, and then they've been rejected at the last minute. I mean, one of the cases that really I found quite harrowing was an Afghan that had bought dresses for his little girls, and they were so excited to get off on a flight to Britain, only to be he'd even been given the flight details, and then he was told at the last minute, actually, no, Home Office checks mean that you can't come anymore, and then America accepted him. Just stories like that it's all been quite chaotic over the years, and everything happened too late. They started asking more Afghans to come, but then op-pitting happened, and there were people just abandoned. There were people allowed into the airport and then told, actually, you're not on the list, so you've got to go out onto the streets where you could be killed by the Taliban. And we reported that two people who were allowed into the airport in Kabul were then later killed after being thrown out by the British. So it's I think ungenerous and cruel at times over the last decade.
Thank you. It was really inspiring to hear you talk about it, and actually the work you've clearly done, sticking up for people that just don't have a voice. Actually you should be really proud of that work. I mean, the LGA is clear, and, we've already talked about this. The lack of coordination between government departments is clearly a huge issue, and obviously there's a debate as to which government department should have been part of this, but, clearly the lack of coordination was a huge issue. What do governments need to learn from this, when it comes to that sort of coordination between government departments moving forward?
Well, there was, I just said about meeting Ben Wallace and Priti Patel, because obviously Priti Patel was Home Secretary at the time and Wallace was Defence Secretary. And actually that was a good example of where they were working together to try and change the policy. And you needed Priti because it was about bringing in wives and family members and making that process more streamlined. And then you needed obviously Ben Wallace because he was responsible for bringing all the interpreters and the people that served the British military. But in recent years, they do need to work better together, and you need the Foreign Office working with the MOD officials to make sure that the policy is all joined up. And actually, one of the problems is that a lot of the Afghans don't really know which scheme to apply for, so they'll apply for all of the schemes, and then you'll have multiple cases of individuals, and it's really hard to know who should come under what scheme, and they don't even know. So it just needs more clarity, the whole system.
And then, coming back to the plight of Afghans, and your work presumably continues, and, obviously we're approaching the sort of cliff edge on the transitional accommodation for Afghans that have come, December this year. Have you got any thoughts on, how government are approaching the risk around that cut-off, and, obviously risk of homelessness being, the big, risk in all of this?
Well, I don't actually know any details about how they're going to manage that situation. I know there's still Afghans at military bases, I know there's still Afghans in accommodation in Inverness actually. But yes, I don't know the specifics on what they're planning to do to manage all of that.
Something that we should probably
Yeah, I'd be
ask
really
about.
interested to know. Yeah.
Thank you, John.
Well, thank you much. I believe Lincoln Jock wanted to come in on this.
Yeah, just a quick one. The obviously part of the reason why we're looking after the Afghans is because this won't be our last rodeo, and we want to be able to go down range and rely on, to a certain extent, consent in order to be able to operate amongst the people. Amongst your contacts, both still in Afghanistan and Pakistan and military bases back in the UK, have people expressed to you a regret for having worked for the Brits, or are they positive about the experience? Would they do it again?
I think a lot of them would do it again. And actually, I spoke to a former interpreter who actually I based my book on, called Jamal Barak, and he was saying that I asked him about what Afghans were facing in the UK, and he said that basically he doesn't feel safe going to the local mosque in his traditional clothes. And that his family suffered significantly for this country, but he also wanted to make the point that we're happy to fight and even die for this country. And I think a lot of the Afghans are really, despite some of their experiences, they're really proud of serving with the British military. However, I do think there is a concern that if you want to employ these people in future, what is the policy? And I would have to check, but I know that I've written previously that since the Afghan, sort of the chaos surrounding the schemes, they then decided to employ interpreters via third parties when they had a deployment somewhere else. So actually, what is their policy now when they employed interpreters abroad? It'd be really interesting to see if that's a whole policy to employ them via third parties so they don't have responsibility for them further down the line.
Thank you.
Right. Well, it's become abundantly clear that there were various government departments that were responsible for different aspects of the resettlement and other issues pertaining to this. But in your view, who should we have in front of us in terms of former ministers and current ministers?
Ben Wallace, Grant Shapps, James Heapy. Anyone else?
Well, all the current, and Luke Pollard.
Yeah, all the current ones, yeah.
Current ministers as well.
Haley.
Anybody outside of the Ministry of Defence?
There's the people in the HEA meetings, if you can get them.
Yeah.
Natalie Moore might be a good one. We heard from her quite a lot in the court proceedings.
Mm-hmm.
She was the one that said in a statement about the providing cover.
Yeah.
So she'd be quite a good one to speak to.
Anyone from the Treasury who could explain where they thought the money was all coming from.
Yeah.
Treasury. And given the housing allocations, do you think that there was anybody involved within the MHCLG?
Not that I know.
Not in the ministerial meetings, I don't think.
I think they were in them.
Were they?
I think we have to check the membership of the HEA, but I think there was someone from MCL.
Right, okay. Well, it's good to get your opinion on that.
I'm going to say any former Prime Ministers?
Yeah, all of them. Why not?
Okay.
Well, they knew about it. So.
Yeah, of course.
All right, let's move on to Fred Thomas.
Thank you, Chair. I just want to come back for a second to this question we were discussing a minute ago about the kind of wider question of resettlement of Afghans and Afghans from particular units, because as we ascertained earlier, there's an overlap with this particular data breach. And Holly, you reported in July of this year about this inquiry that 2 judges reported on into some of the MOD casework and the processes that were carried out for whether or not to give refuge to particularly special forces Afghans. And you quote the judges, and I'll read it out because it's quite powerful. You say caseworkers, along with a liaison officer from UK Special Forces who was assisting them, quote from the judges, were not given access to relevant records relating to payments, and so didn't know that these Afghan fighters had received direct pay from the British. You then write, MOD officials were also, quote, overly reliant, that's a quote from the judges, on UKSF, UK Special Forces personnel for input, and, quote, placed too much weight on personal knowledge and judgment," end quote. One UKS Special Forces liaison officer tasked with investigating applicants' links to the Special Forces would refuse applications if the relevant UK Special Forces unit failed to respond to his inquiries, the judgment found. So what I would like to know is just from your opinion, because you've clearly looked into this closely, you've reported on it, is your sense that this was just incompetence, or were these Special Forces liaison officers, as has been suggested by the BBC, doing this on purpose?
I think from that court case, there wasn't anything submitted that showed malicious intent. But yeah, essentially a guy in the role of a liaison officer just refused all of these applications. And I think that goes down to, whether the MOD is right to be doing this casework, and who has the right expertise for it, because essentially you have caseworkers who don't have the specific knowledge of this unit and what their role was and how they were paid or not paid, and then they're relying very heavily on an individual, a number of individuals who do have that knowledge or can access that sort of information. And so the process is essentially led to, I don't know, there's always back and forth about whether you can say blanket refusal, but yeah, a lot of these triples being refused because no one really knew their service who was actually assessing these applications. And I remember at the time we were like saying, you paid these guys, and then they were saying no, we didn't, and then then later pay records emerged. And so I think there was within the MOD like a lot of knowledge wasn't accessible to some branches of it, and then they made wrong decisions, and then that also made them overly reliant on people with UKSF links to like try and but in terms of figuring out whether that can be linked to the ongoing Afghan inquiry, I think the BBC probably have the best sources on whether that is the case or not. That didn't emerge in this court case, but that doesn't necessarily mean that it's not the case. But it's maybe someone to ask the BBC. Really.
Sure. Either of you want to comment on that?
No, I don't know.
I didn't
Details
comment.
enough.
All right, okay. Thank you.
Thank you much, Calvin Bailey.
Thank you. Just because it's been raised a number of times, I would like us to recognise the extraordinary efforts of the servicemen and women who delivered Operation Pitting under exceptional duress as a result of failures that they had to overcome and make the decisions which you spoke about on the gate in and under exceptional duress. And I do want to try once more, what was the Foreign Office's place in applying that duress onto the organisations that resulted in this failing? There's just been no comment. In the people that you would like us to see in front of us, you have not mentioned Dominic Raab, who happened to be on leave when Op Pitting occurred.
I don't have anything further to add. I just can't remember I can't remember the specifics at the time of what the Foreign Office were doing. I just remember that some of them left Kabul and the MOD had to send people in at the last minute.
There was an inquiry into the Op Pitting response, because I remember there was an Afghan whistleblower, a whistleblower within that department, who gave a lot of evidence as to the chaotic nature of the FCDO response in particular. But I would have to go back and read that review. But I don't know anything about whether that left the MOD having to pick up the pieces or anything.
Okay, the decision to evacuate is a Foreign Office decision.
Okay.
Right, thank you very much. I am extremely grateful to yourselves, Ms. Bancroft, Ms. Brown, and Mr. Greenhill for giving evidence. This was the first hearing within the Defence Committee's inquiry into the Afghan data breach and resettlement schemes. No doubt over the next few months we will be delving further into this, but I am extremely grateful for your written contributions as well as for giving evidence today. And as I intimated at the outset, that I certainly, on behalf of the committee, I'm very, very grateful to journalists for their grit, their determination, their pursuit and their perseverance to expose this entire chapter where everybody was kept in the dark, including many of us as parliamentarians over those couple of years. Thank you very much. Order, order.